Hello, my name is Dr. Debaruti Khaldar and I'm the professor for Department of Research, United World School of Law, Gandhinagar, Gujarat. I'm also the honorary managing director for Center for Cyber Victim Counseling. This module is titled as Online Privacy Protection. This module will help us to understand the concepts of online privacy and privacy protection and protection measures, the responsibilities of the service providers in online privacy protection, the Indian regulatory provisions regarding data privacy and online privacy and practical needs for the creation of awareness among people about online privacy and privacy protection. This module is divided into 5 parts, that is, introduction, need for online privacy, types of offenses related to online privacy, and summary and conclusion. Privacy in one word may mean right to be left alone without anyone, unethical intrusion. Warren and Brandeis highlighted right to be let alone as the center point of the concepts of right to privacy. Online privacy protection may imply a holistic concept of protection of online data, including financial data, reputation, and protection against unethical surveillance by the government or government-aided agencies. Due to huge penetration of information technology into all sectors, including health, education, banking, and even in social relationships, online privacy has become extremely vulnerable. The financial data, including the banking data provided by the customer to the bank, or the health data generated by a hospital for monitoring the health condition of a patient, or financial or private residential data provided by the customer to the e-commerce companies, or employee profiles collected by the workplaces, or the personal data generated by the user of any social media and provided to the social media company, etc., may be vulnerable data which, if breached, may bring harm to the original owner of such data, that is, the individuals concerned. These data may be collected by private companies or the public sector organizations like the government, banks, government hospitals, etc. In certain cases, the public sector organization may also include several government departments issuing identity cards, policies, licenses, etc. However, it would be wrong to say that such government departments may be solely responsible for protecting privacy and confidentiality of the data from the starting of the gathering of the data till the end, that is, disseminating processed data in the tangible form, like the election identity card, Aadhaar card, driving license, etc. This is because the government may engage several private companies to collect and process or provide final processed data. As such, even though the company concerned may be directly liable for the breaching of the privacy of such stored data, government may also be vicariously liable for the same. It may be pertinent to note that the term online privacy is not defined under any law in India, but the Information Technology Act defines data under Section 2(o), which states as follows. Data means a representation of information, knowledge, facts, concepts, or instructions which are being prepared or have been prepared in a formalized manner and is intended to be processed, is being processed, or has been processed in a computer system or computer network and may be in any form including computer printouts, magnetic or optical storage media, punched cards, punched tapes, or stored internally in the memory of the computer. It may further be pertinent to note that the information technology reasonable security practices and procedures and sensitive personal data or Information Rules 2011 under Section 3 defined sensitive personal data as password, financial information such as bank account or credit card or debit card or other payment instrument details, physical, psychological and physiological health condition, sexual orientation, medical records and history, biometric information, any detail relating to the above clauses as provided to body corporate for providing service, and any of the information received under above clauses by body corporate for processing, stored or processed under lawful contract or otherwise as may be seen from the above. These are some of the meanings of the concept of privacy as per Indian legal understanding. Need for online privacy. As was held in the case of Karak Singh versus State of UP and others, the Supreme Court of India for the first time recognized right to privacy as a necessary right to every individual. However, it was later included within the scope of Article 21 of the Constitution of India, guaranteeing right to life, liberty and property, and it was not given any separate provision unlike right to education, which was covered under Article 21A of the Constitution of India. Privacy in the real world may be protected by applying constitutional rights as well as by preventing intruders from entering into one's own premises or by preventing unwanted intruders from infringing into the notion of privacy by way of installing spy camera or voyeurism. But in the virtual space, protection of privacy may arise several issues, including questions regarding liability of the body corporates who preserve the data, what types of data may be categorized as that which may need privacy protection and why it should be protected, the types of data that may be stored by the body corporates and their usage of data through information and digital communication technology are as follows: financial data for banks and e-commerce, health data for medical and social welfare scheme, education data for higher education, employment, private data and social media, and for digital communication and general individuals' data for government identity. It may be understood that the data that are gathered from the users may be fed to the data bank of particular body corporates for different reasons. For example, in case of banking data, financial information of any individual may be stored by the particular bank and may be used for e-commerce purposes, taxes, loans and credits, and even social welfare benefits by the data provider. Similarly, information provided to the health sector may be used for monitoring the concerned person's health, preventing him to be exposed to more risky environment, providing financial benefits under government social welfare schemes, etc. Community health data may also be used to map spreading of viral disease. Further, individual personal information including date of birth, names of the parents, children or spouses, etc., which may be generated by the government for various purposes and schemes including election, common database, ration card, etc., may have multi-purpose needs. Day-to-day communication generated via digital telecom and information technology services may also be considered necessary for keeping records of important personal, corporate or government communications, or even to detect several criminal behaviors of individuals targeting individuals, corporates or government organization. Such data generated by various organizations may also be beneficial for securing right to education for children, getting higher education or for employment. Types of offenses related to online privacy. As has been seen in the above, data can be gathered and stored by body corporate for several purposes. Privacy infringement related to offenses may happen targeting three types of targets, that is, government, corporate and private individuals. The offenses related to online privacy can be discussed under following heads, namely unauthorized access to the computer, computer network and the data. Popularly, this is also known as hacking. As per the Information Technology Act 2000, amended in 2008, unauthorized access to the computer, computer system and computer network and data without the permission of the owner is considered as a civil offense as well as a criminal offense under sections 43 and 66 respectively. While in case of civil offense, it is dealt under the broader title of penalty and compensation for damage to computer, computer system and others. Offender is made liable to pay compensation of not more than 1 crore to the victim. In the second case, it is dealt under the broader term computer related offenses and 3 years punishment or a fine of an amount which may extend to rupees 5 lakhs or both is prescribed. Unauthorized access to computer, computer network, etc. may even cause grave offense like defacing government and private websites, stealing of secured government data, or may even cause cyber terrorism, identity theft and impersonation. As this term suggests, fraudulent use of usernames, passwords, authentic names, identity cards, designation, photograph, etc. may result in identity theft for financial and emotional cheating. In such cases, the stolen identity or the identity thus modified in unethical and illegal manner may result in impersonation. The Information Technology Act 2000, amended in 2008, prescribes punishment for identity theft by way of imprisonment for a term of 3 years or with fine or both, under section 66C and also under section 66D. Impersonation with similar punishments. Similarly, Indian Penal Code also prescribes punishment for impersonation by way of financial cheating under section 417, 419 and 420. Phishing. The meaning of phishing may best be explained with the help of definition of the term provided by web companies like Google. According to Google, phishing is usually done through email, ads or by sites that look similar to sites you already use. For example, someone is phishing might send you an email that looks like it's from your bank so that you will give them information about your bank account. Phishing emails or sites might ask for usernames and passwords, including password changes, social security numbers, bank account numbers, PINs, that is personal identification numbers, credit card numbers, your mother's maiden name, your birthday. Phishing is essentially an economic crime whereby financial data may be breached and unauthorizedly accessed by trick. Under the Indian laws, phishing is regulated both under the provisions of Indian Penal Code as well as under Information Technology Act. Data theft. While the concept of data theft may be understood in the light of the above mentioned offenses, data theft may also happen in corporate houses by employees or any other persons or group of persons who may breach the confidentiality for knowing about the official secrets, profiles, or salaries of other employees, or even financial information of the company concerned. Data theft may also occur targeting private persons whose private documents or photographs, etc., may be stolen for causing financial harm and reputation damage. Cyber stalking. Commonly, cyber stalking means repeated following or monitoring a person to commit harm. According to Bosage, Griffiths and McFarlane's, cyber stalking is a group of behaviors in which an individual, group of individuals or organization uses information and communication technology to harass one or more individuals. Such behaviors may include but are not limited to the transmission of threats and false accusations, identity theft, data theft, damage to data or equipment, computer monitoring, the solicitation or of minors for sexual purposes and confrontation. According to Haldar and Jaishankar, in one word, when following is added by mens rea to commit harm and it is successfully digitally carried out, we can say cyber stalking has happened. In many jurisdictions, including India, cyber stalking has been perceived as a crime solely against women. The Indian Penal Code under Section 354D therefore defines cyber stalking as any man who follows a woman or contacts or attempts to contact such woman to foster personal interaction repeatedly despite a clear indication of disinterest by such woman, or whoever monitors the use by a woman of the internet, email or any other form of electronic communication or watches or spies a person in a manner that results in fear of violence or serious alarm or distress in the mind of such woman or interferes with the mental peace of such woman commits the offense of stalking. However, we need to understand that cyber stalking may happen to people irrespective of their gender. Unethical surveillance. While for national emergency purposes, digital surveillance may be imposed by the government to regulate terrorism activities or offenses against the nation or humanity as a whole. In general, unauthorized surveillance is illegal and against constitutional rights of privacy. In unethical surveillance, phone communications may be tapped or email, social media communications may be monitored without any specific need. Such necessity may include checking a person's criminal background or getting digital evidence about any crime, etc. Violation of bodily privacy by digital communication technology, that is voyeurism. Violation of privacy has been addressed by the Information Technology Act 2000, amended in 2008, as well as by Section 354C of the Indian Penal Code from the perspective of capturing images of the private body parts of an individual. As per Section 66E of the Information Technology Act 2000, amended in 2008, especially women, as per Section 354C of the Indian Penal Code, without that person's consent and knowledge by digital means. Section 354C of IPC has further expanded its scope by covering the act of disseminating such images without the consent of the person whose private body parts were thus captured. In a way, voyeurism may mean upskirt photography or secretly capturing the private body parts and also storing those images in one's devices, as well as disseminating the same to others without the victim's knowledge. Both Information Technology Act as well as the Indian Penal Code prescribes punishment for imprisonment for 3 years or fine or both. Morphing. Morphing in general means doctoring a genuine picture to provide a false impression. Examples for morphing can be digitally changing the face of a person in a photograph, etc. In the context of online privacy, it may often be seen that individuals, especially girls and women, may be victimized by morphing, whereby their faces may be used to create nude or porn images by attaching the face to the nude body of other women. Morphing may be a separate criminal behavior or may be associated with other online privacy infringement offenses, including hacking and identity theft. The Indian laws address morphing mostly from the perspective of creation or production or dissemination of sexually explicit materials. Revenge porn. Revenge porn can be defined as an act whereby the perpetrator satisfies his anger and frustration for a broken relationship through publicizing the false sexually provocative portrayal of his or her victim by misusing the information that he may have known naturally and that he may have stored in his personal computer or may have been conveyed to his electronic device by the victim herself, or may have been stored in the device with the consent of the victim herself, and which may essentially have been done to publicly defame the victim. Revenge porn is slowly being recognized as an offense connected with online privacy in India. There is actually no focused law to prohibit revenge porn in India right now. Summary and conclusion. Readers may note that online privacy is an essential substance in the present day. The generators of data, that is, the private individuals, may contribute their personal and sensitive data to the body corporates. Body corporates are any company and includes a firm, sole proprietorship, or other association of individuals engaged in commercial or professional activities. These body corporates are liable to provide protection to the personal data stored with them. However, often body corporates may escape their liabilities due to third-party liability policies and due diligence policies, which states that they would not be liable in cases the infringement of privacy has occurred without their help, or the users knowingly did not use the privacy safety mechanisms that were provided to them by the body corporates, etc. India is yet to have a full-fledged law on online privacy protection, since the Privacy Protection Bill 2012 is yet to be promulgated as an act. Further, several of the offences related to the online privacy are yet to get legal recognition. However, the government as well as several NGOs and other body corporates themselves from time to time provide several guidelines or tips, etc., for the common citizens to protect themselves from online privacy infringement. These may include the followings: not to tell others about the ATM PIN, not to respond to hoax calls about banking details, not to chat with strangers online, not to share personal pictures and information with strangers, etc. Thank you.